So somebody's sitting there going to lien you. Tim McAdams, your construction experts. Contract, lien, what does it really mean for you as a homeowner? Well, I'm not a lawyer, okay, but I can tell you, being licensed in 3 states as a contractor, okay, I'm going to share with you the way I understand construction liens that work. First and foremost, what a lien is when basically a company, usually a contractor, comes in and files a position against your piece of property. If you're a legally licensed contractor and you have the legal contract that's performed properly and executed properly as required by whatever legislative agency governs that, because if you breach your part of the contract, then you could be subject to having a lien put against you. But you're going to lien me, so what? What does it really mean? Well, here's what it really means. And this is what it means to me as a contractor, and this is how I view it as a contractor, not as an attorney. If I walk into a house and I do a job, and I use a particular publication company that does annual updates to the rules and regulations in any particular state. So for instance, this contract right here that's in the state of Florida, it's actually a 12-page contract. A lot of it's boilerplate related items, but what it is it's what's been determined that in a court of law, a judge will look at that and respect this as a legal binding agreement. No different than if you bought a car or if you bought a house or whatever you might buy. Okay, and a lot of contractors, and especially handymen, will work off of a legal pad. And I'm not saying that there's one right and one wrong or whatever, but I do know for my company and the way that I run my business, there's only one right, and that's using a legal required document that the state's got every mandate in it. So that if I do have to go in and enforce a lien, which by the way, I've never had to take somebody to court to enforce a lien. I've managed to work through the process, whatever it may be, but I've been put in situations where I have had to threaten to lien people. But even if you lien somebody, okay, in the state of Florida and the California, they have different rules. These happen to be 2 of the 3 states that I'm licensed in. But a lien basically means that you live at XYZ address. This particular construction company has come in and filed a lien against you over work that was performed at your house that they probably weren't paid for, is the way they feel about it. Now, that alone is not enough to ensure that they're going to get their money. What that usually does, certainly in Florida and California, is that I can walk in by 9:15 in the morning. If you owe me a payment at 9 a.m., all right, and you don't pay me, and I feel concerned that you're not going to pay me, by 9:15, I could walk into the courthouse, and me as a legal contractor, with this legal contract, I can lien that piece of property, so that if you decide you want to sell that property, you have to satisfy that lien, or if you want to borrow money against that property, the title companies will be interested in it. But what that really means for all intents and purposes, just because you've had a lien filed, is not an automatic win when you go to court, okay? And what I mean by that is that when you file the lien as a contractor, okay, you're saying John Doe at XYZ address breached this contract by failing to make payments based on our pay schedule in this contract, or in a contract, if you will. Okay, that starts a clock of 12 months, I believe it is in Florida. I think California is 6 months, that contractor has to actually initiate legal proceedings against you to take whatever evidence they have. If it's the contract, if it's text and email conversations, if it's videos of the job, or whatever evidence that they can amass to take in front of a legal binding judge in a court of law, okay, and get the judge to ratify that lien, okay. They only have 12 months to do it, I believe it is in Florida, and don't hold me to this, I'm not a lawyer, but I'm a contractor, and this is kind of what I live by, creed by, okay? I understand where the rubber meets the road. And where the rubber meets the road in the contracting business is really simple, okay? I am the legally licensed entity, okay? I'm the guy that holds the licenses. I'm the guy that's supposed to know what's legally required in the contract, not the consumer. I've never filed a lien that I wasn't able to remove quickly, okay? But at the end of the day, I've never had to enforce one by going through a court of law, but this is my understanding on the way it works, okay? And so I filed a lien today, okay? In Florida, you have 365 days to basically get that in front of a judge if you're the lienor, okay, which would be a construction company in most cases. Now, this may come as a great surprise to you, but oftentimes a handyman will attempt to do a lien on your property. Okay, and there are very strict rules regarding who can lien a piece of property, who can't lien a piece of property. Okay, and when we get a little further into this conversation, you wait till the end, then I've got something I'd like to share with you, which are some real life stories about how handyman didn't really have the strength that they thought they had when it comes to enforcing getting paid for a job. And I'll share that with you at the end of this video. But let's get back to the actual lien process itself. So now you've got your lien. It is recorded on your house. If you went to get a loan tomorrow, the bank would see that there's been a lien imposed on your house. They have a year basically to file a lawsuit, to get you in front of a judge. Now, the homeowner can expedite that by filing their own response to that lien in the state of Florida. So you can actually expedite that process, and it doesn't have to be a year. It can be as quick as you can get it into court. Because the minute that you find out that you have a lien, then you have the right at that moment to get a lawyer, if you want one, go ask for a court date, to basically ask that contractor to enforce that lien by providing the evidence to a judge that they're entitled to it. And you as a homeowner are going to need to provide some sort of evidence or reasons why, or reasonable rationalization, hopefully in writing, okay, that will convince a judge that that lien is not done properly. And I can tell you, okay, just from being holding 7 licenses in 3 states, and I haven't been in front of a judge with my licenses, but I know enough people that have. And when you're the licensee and you walk in and you don't have all the documents in place that you need to in order to be able to enforce your lien, you're going to lose. Okay, and that's why I pay a company, and I have been for over a decade, to make sure whatever state I'm operating in, I'm meeting most current codes and regulations with regard to the clauses that are required in a specific contract. A handyman usually works off of a legal pad, might be the greatest guy in the world, okay? But at the end of the day, handymen in most cases don't have the ability to go in and lien like a contractor does. And even if they do get a lien on your property, they're going to have to get that lien in front of a judge. And a judge is going to look at it, and if they're in violation of law by acting as a contractor without a license, odds are they're not going to fare real well in court, okay? So all you handymen out there, you need to understand that when you're doing a job as a handyman, you don't have as much power over the job that you might think you do in terms of being able to collect your money. And what I mean by that is legally licensed, legal binding contract, did the job properly, documented it properly. And by the way, very important throughout your job, when you communicate with your contractor, if you communicate by text message or by email, it is far better than having verbal anything with regard to your job. And that doesn't mean you have to be, distrusting and every little thing has to be said. But let me tell you, if you prepare for the worst and you hope for the best, you're better off when you deal with something that may end up in court, okay? Because let's face it, you haven't done many construction jobs before. You don't really know what's going to happen until the job's over with. And you can go from the penthouse to the outhouse in a hurry, okay, on a construction job, okay, if you say one thing and they misunderstood another. If you put it in writing and they respond accordingly, then you're both on the same page, and that can easily be laid out in front of a court and say, well, here's the conversation we had. Here's what I sent. Here's what the response was. The judge is going to look at it and go, okay, that's not a he said, she said. It's right there for you. I'm not saying prepare to be legally bound up in court all the time, but I'm saying protect yourself as a consumer. You can reach out to me, Tim McAdams, your construction experts. I can talk to you further about this. I mean, I'll tell you straight up, I have a lien showing on my property, and I didn't even know it, okay? I don't have anybody that I haven't paid any money to, but about a year and a half ago when I did my refinance, when the numbers were low, I went to the bank and I did a refi, and they did a title search on my house, and they actually found a lien from a granite company, and it was in the amount of $800. I never was notified of the lien, okay? And the way it was explained to me in Pinellas County, so I didn't even know the lien was there, okay? All right, so to my amazement, I'm like, what do you mean my house has got a lien on it for $800? And I looked it up, or they sent me the document on it, and sure enough, it was a granite company that I had a dispute with. Okay, and the fact of the matter is that I knew I was right. I was never spoken to about the fact that I had been liened. Okay, but here's what ended up happening. And I'm just going to use arbitrary dates because I don't have the specific dates in front of me, but it was about 3 years ago. So let's say it was around January the 6th of 2021. This lien was filed against my property for $800. That lien is recorded against this plot of land and this house at the county courthouse. That's how the title companies and the banks find them when they go to look at your title of your home to see what kind of encumbrances you may have to keep it from either being loaned to or bought or sold. Okay? Well, what ended up happening was, is this particular refinance, I did it in March of 2022. All right, so what ended up happening was, first the mortgage title people come back to me and basically went and said, well, you have a lien. I said, well, it's not an accurate lien. I've never heard nothing about it, okay? And they looked at the date on it and they go, oh, I think it was January the 2nd, 3rd, whatever it was of 2021. By then it was March of 2022, which was over the 1 year period. So what they did is when they dug deeper, they realized that that lien was never enforced by a court of law. Okay, but it still doesn't mean that it's still not sitting on that piece of property. And the way it was explained to me is that basically in order for me to be able to get that removed from this piece of property, I would need to go get an attorney, to go in front of a judge and have a judge actually strike down the fact that the lien was there, and the county at that point that would then physically remove it from the record. But because in my situation, it doesn't matter to me, it's not a legal lien. If I want to borrow money, I want to sell my house, I want to do something like that, the title company's going to look it up, they're going to see it's an invalid lien, and it's going to be disposed of. Do I like it on there? No. Is it detrimental to my property values? No. Is it detrimental to my credit? No. You know why? Because it never was taken in front of a court of law. Okay? That's the very most important part of this. Is it a pain? Yeah. It was a couple of days where I had to deal with something I want to deal with, but don't be afraid of a lien. Be prepared for a lien. Okay? And when they're prepared for a lien, that's when I go back to read that contract. Put your addendum in the contract to make sure that what you are signing. And it may be overwhelming for you folks, but on a $10,000, $12,000, $15,000 job in the state of Florida, this contract I'm showing you right here, I just sent this out to someone 2 days ago from my company, Premier Home Repair. This is a $11,000 bathroom, okay? And this particular software program that I use does much of the work of this contract, okay? But it's boilerplated to know that if I do get the job and they sign this contract and I wait the 3-day waiting period, okay, then I'm legally entitled to be paid for this job because it's now an officially executed contract. That's the way I view it as a contractor in the state of Florida. What I would like to consider the greenhorn contractors that are out there, the eager to go get them, I want to do it tomorrow's, this kind of thing. In the state of Florida, when you sign a legally binding contract for construction work at your residence, okay, it comes with a 3-day right of rescission. What does that mean? Is that as a legal contractor, I present you with a $12,000 contract on Monday at 1 o'clock, okay? This particular client, even though they gave me 10% down on the job, even though they're all gung-ho to get the job done, they'd like for me to get started early. They want me to start Tuesday or Wednesday or Thursday. As a legal contractor, knowing after 25 years of the stories that I can share, and I will share another story with you very soon here, folks, about how a painter ended up having to paint an entire house, a $27,000 job for free because he didn't wait for the 3-day period, okay? For over-eager contractors that want to start before that 3-day period's up. So Monday at 1 o'clock you sign. Tuesday is 24 hours. Wednesday at 1 o'clock is 48 hours. Thursday at 1 o'clock is 72 hours. 3 business days. Now, you might say, well, you can start at 1:01 on Thursday. Maybe, okay, that's a gray area that I don't like to get involved with. I automatically, at a minimum, will start on the 4th day from the time I sign that contract. So if I sign that contract on a Monday at 1 o'clock with the customer and they sign it, I will wait Tuesday, Wednesday, and Thursday. And my first time I'm going to show up on that job, because it's an executable contract at that point, is I'll already have an appointment to be at that job at 8 or 9 o'clock on that Friday morning at the earliest, so that I know I have what's known as a seasoned contract. And when you got a contractor that knows the rules, okay, and has got a contract that's got all the provisions, that's got the ability to do the job, they deserve to get paid, okay? And that's what you're paying for when you're paying for a professional license, okay? You're not paying for some guy to sit out in his driveway and write something up on a legal pad and to give me maybe yes or that, blah, 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 and give me half down. There was a neighbor in my neighborhood that just got taken $12,000 for a fence by an unlicensed company, okay? It was on Nextdoor, one of the applications. And it was sad, but I read the story. I've reached out to the neighbor. I'm going to help him as the best I can. But I couldn't believe that somebody would actually give somebody $10,000 down on a $12,000 job. Different story for a different day, but let me just say this right here. back to the legal enforcement of the lien. Now that they've got your lien, okay, they're going to try to get it to court too, unless they're just trying to be aggressive and want to cause you issues and think it's a big deal to lien you. A lien by itself is no big deal. A lien that's been ratified by a court is enforceable by law. And the way I've always looked at a lien is if I did have to file a lien on a piece of property and I actually came out a winner, whether I got paid or not, for me, it didn't bother me that much. And it may sound weird, well, why didn't it bother you that much? Well, it just goes with the territory. Okay, let's say I have a $20,000 contract, and throughout the course of that contract, I get $10,000 or $12,000 or $15,000 down. That means a great deal of my profit is sitting at the end of the job. And if the customer doesn't want to pay me that extra $5,000 or $7,000 to close out the contract because they don't think they have to, I march myself right down to that county courthouse. I file me a lien. I take my contract. I go to court. I get a judge to go, yeah, you, Mr. McAdams, you're entitled to the amount of the contract plus your attorney's fees, in my case, okay, if it were to come down to that, okay? And at that particular point, now you have a lien against your piece of property that can't be removed until it's been paid. And you can think, well, that still doesn't get me paid. No, but you know what it does do? It starts an interest percentage clock. Because I get to collect 10% per year until that piece of property has to transfer hands. A bank or institution requires them to satisfy that lien, but it ain't going anywhere, okay, because it's been ratified by the courts. Sometimes they have to be renewed every 7 years, like in the state of California, which is a minor process. It's $50 or $100, and you renew it for the next 7 or 10 years. But either way, there's a complete legal process for being able to collect money if you're a legal contractor.